We now move on to Learning Unit 1, Theme 4. And again, just a short outline. So what we're dealing with here is the demise of legislation. So how does legislation stop applying? When does it no longer work? So the question is, how has legislation changed? There are a couple of ways. The first is amendment. That is when amendment means change. That is when legislation is changed. Or by repeal, and that is when legislation is deleted. It's taken away, it doesn't exist anymore. So we'll start with amendment. There are two kinds of amendment: formal amendment and modificative interpretation. Modificative interpretation is done by the courts. So despite the fact that we have separation of powers and the court has a judicial function, the court also has a secondary lawmaking function. And it is required by the Constitution to develop the common law to make sure that it's in line with the Constitution. And it also has a function where it tests legislation against the Constitution. And in the performance of that duty, the court performs a secondary lawmaking function. So when we're looking at formal amendment, only the legislative authority who passed the legislation may amend it. So if National Parliament passes an act, only National Parliament may amend it. Similarly, for a legislation passed by a provincial parliament or by local councils. Modificative interpretation is done by the courts. So how does the legislative authority change or amend legislation? There are two ways of doing it: non-textual or indirect, when the wording in the legislation is not actually changed, but the amendment describes changes in the law referring to which provisions will be changed. Or there can be a textual amendment. That's a direct way of amending it, where the words of an act is changed. Some words are taken out and other words are put into its place. Modificative interpretation by the courts is done during attempts to save legislation when there is a constitutional review. So you will be aware that a number of different parties have challenged the validity of both the Act, the National Disaster Act, as well as the regulations that were issued under that. And when the constitutionality of legislation is challenged, and the court has to measure that legislation against the Constitution, and if it's possible to change something, a word or a sentence, and then something which is unconstitutional becomes constitutional, that is called modificative interpretation. So that's where the court says, well, clearly this is constitutional, so that's how we will change it. And it also happens during interpretation. So sometimes a party would approach the court and ask the court, please tell us how this would be interpreted. Or during a dispute about how a piece of legislation is implemented, the parties would argue, but that is not what the act means. You clearly misunderstand it. And the court would then interpret that legislation, and it may then change the meaning. So it doesn't change the words, but it says this is what it means, not X, but Y. So again, let's deal with the regulations, that the COVID-19 regulations. You have a regulation that says that tobacco may not be sold. So what does that mean? It means that it can be manufactured, it can be transported, it can be exported, but it cannot be sold locally. So that would be interpreting what it means, and that would change the regulation that we're dealing with there. So who can repeal legislation? Firstly, the person who made the law can repeal the law. And secondly, again, the court play a role, because if a piece of legislation cannot be interpreted in such a way that it becomes constitutional, then the court can invalidate it. When it's invalidated, it means that it cannot be enforced. So when Parliament makes an act and they change their mind and they decide we no longer want this act in place, then they can repeal the act. That means that it's no longer there, it doesn't exist. Transitional arrangements can also play a role in this, and section 12.1 and 12.2 you need to look at of the Interpretation Act, and you will go through that with your campus lecturers. Sunset clauses are pretty important. It's something that often comes up. An example of that would be the legislation that applied during the Soccer World Cup. I think it was in 2010 that South Africa hosted that, and there were lots of regulations made that applied only for the duration of the Soccer World Cup. So what happens is, here's a piece of legislation. It's going to apply for the next 6 months, and then it's going to stop applying. That's your sunset clause. It means that it's got a limited lifespan, essentially. Then the court may declare, and here we're only talking about the Supreme Court of Appeal or the Constitutional Court, may declare legislation unconstitutional if it violates a fundamental right or it's in conflict with the constitutional requirement. And it will immediately mean that all subordinate legislation, so all regulations that were made in terms of that act, would be invalid as well. So if the court declares a piece of legislation invalid, it doesn't disappear off the statute book. It is still there, but it may not be enforced. Only Parliament can repeal it, delete it off the statute book, but it cannot be enforced because it's been invalidated by the courts. So there's some cases that you need to look at. Makwabyane was where the court declared the death penalty unconstitutional and nobody else was allowed to be executed, and later on Parliament went and changed the Criminal Procedure Act and removed the death penalty as a possible sentence from there. The Prince Winners versus Minister of Justice and Constitutional Development case from 2017 deals with cannabis, and this is an interesting one, and you need to go and find this case and read it because it demonstrates invalidation quite well. So the court said that it is an invasion of a person's privacy to prohibit them from smoking cannabis in the privacy of their own home, and ordered Parliament to replace the legislation. Parliament has not yet done that. So Section 2A still sits there, and it still says that it's against the law to possess cannabis, but it may not be enforced because the court has declared it unconstitutional. It's been 3 years, and we're still waiting for Parliament to give us clarity. And it's necessary in a case like this for Parliament to give us clarity, because how much cannabis may I have in my possession for personal use? What's reasonable? What is privacy? What is in private? Does it mean in my own home? Does it mean in my car on a public road? Does it mean at a party when there are lots of people but no public access? So all those concepts need to be defined by the legislator when they actually eventually get around to rewriting that particular piece of legislation. Then legislation can be suspended. So that is what I've just explained to you really happened in the, invalidating. It doesn't apply, but there can also be a suspension of legislation on a temporary basis. So you can't start enforcing a piece of legislation until the regulations have been promulgated. The pharmaceuticals is a good example of that, because without the schedule, which tells you which drugs are Schedule 7 and 8, you cannot possibly enforce the law. So then the operation of the main act is suspended until such time as the regulations are issued, or if there is a conflict with a different piece of legislation and that needs to be sorted out. What you do need to remember here is that here's another presumption. And that presumption is that legislation does not intend to change the existing law more than is necessary. And existing law refers not only to legislation, but it refers to law, small l, not a capital, no, other way, yeah, small l. So both legislation, common law, and customary law are the law. And when a piece of legislation is promulgated that changes that, the court will always interpret it in the least invasive manner possible. So we change as little as possible because that is the presumption that the court has to apply. Thank you very much. And that's the end of this one.